the next section of the rules, client confidentiality. Client confidentiality makes up 6 to 12% of your exam. I really like this section of the rules because I feel like you can truly maximize your chances of success here as it relates to the questions that test this material. And that's because if you flip through this whole section, you'll realize that there's not that many rules here. Now, these rules can be tricky, and of course, therefore, the questions that test them will be tricky. But if you spend time memorizing the rules in this section, you'll see that you'll start to get these questions right. So, the first place I would like to start is to summarize the differences between the attorney-client privilege and our duty of confidentiality. Then we'll segue into talking about the attorney-client privilege and its exceptions. And then we'll head over to that duty of confidentiality and its exceptions. So in terms of the differences, our attorney-client privilege is technically an evidentiary rule. And therefore, it's going to prevent a court or a tribunal from using its powers to compel the revelation of confidential communications between an attorney and a client. This is in contrast to our professional obligation of confidentiality, which prohibits the attorneys from voluntarily revealing information that relate to the representation of a client. So stopping there, the duty of confidentiality is an ethical rule. The attorney-client privilege is an evidentiary rule that protects us lawyers from being forced to reveal client confidences in court. The next difference is the attorney-client privilege protects only confidential communications, whereas the duty of confidentiality covers confidential communications and any other information relating to the representation. I'll remind you about this in a second, but our duty of confidentiality is much broader than the attorney-client privilege. And the attorney-client privilege only prohibits the disclosure of information, where the duty of confidentiality prohibits the disclosure of information and using it against the client. And you're going to see how the duty of confidentiality also pokes its head up again when we talk about the conflicts of interest. So now that we know the differences, let's take a look at the rules. Turning to the attorney-client privilege first. The rule says the attorney-client privilege is an evidentiary rule that prevents a court or other governmental entity from using its powers to compel the revelation of confidential communications between an attorney and a client, or agents of either. So let's define some of those important words we used in that rule statement. Turning first to attorney. This includes anyone authorized or who the client reasonably believes is authorized to practice law in the state. The attorney must be acting as an attorney when the communication is made, rather than as a friend or a business partner. In other words, you always want to check the context of the communications. Turning to the word client, let's define this. This includes prospective clients, so anyone who seeks legal advice or services from an attorney, even if that attorney-client relationship is never established. Thus, if a prospective client comes to you and tells you all about their legal issue, but then they choose not to hire you, the attorney-client privilege as it relates to that confidential communication exists. Now, when it comes to a corporate client, this can be a little trickier because we know corporations aren't people. Rather, they're ran by people. So putting your finger on precisely who the client is and therefore who that privilege relates to can be a bit more challenging. So turning to the definition, the rule explains that communications between any high-ranking official, think people like the CFO or CEO, and the lawyers will be covered. Further, any communications by an employee and the lawyer are covered, so long as the employee is communicating at the direction of their superior. The employee knows that it's for the purpose to obtain legal advice for the corporation, and that communication concerns a subject within the scope of the employee's duties to act for the corporation. So turning to a quick example on that point. Let's say a company hires a lawyer to investigate some suspected fraud they think is going on internally. And they ask the lawyer to interview specific employees in specific departments within the company. The lawyer is specifically directed to interview a buyer. The buyer is told by his superior, the president, to answer the attorney's questions. And during this questioning, the buyer, the employee, admits that he entered into a whole bunch of illegal agreements. He set prices, and all of this amounts to fraud, which is the precise thing the attorney was there to investigate. The lawyer takes this information and relays it back to the president of the board of directors. They decide to terminate this employee quietly and let him part ways. The company does not turn this information over to the police. Later, a client sues the corporation by virtue of these fraudulent practices. And the client calls the lawyer who had investigated the matter to the stand and tries to elicit the information that the ex-employee had given the attorney during the investigation of the matter. The question is whether or not the company could assert privilege based upon that communication between the lawyer and the employee that had gotten fired. And the answer to that question is yes. Why? Because the employee was talking to the lawyer by virtue of his direct supervisor's orders. He was speaking to the lawyer for the purpose of legal advice. Thus, he understood why the communication was occurring. And lastly, he was talking to the lawyer about something that was in the scope of his employment. Next, turning to the definition of communication. This is defined as information passed from the client to the attorney or agents of either. Turning to the definition of confidential. This is defined as something that the person reasonably believes no outsider will hear. So again, context really matters for these fact patterns. Statements are not confidential if a third party who does not reasonably need to be part of the conversation is present. Turning to the examples in the outline. If a client brings her accountant to a meeting and an attorney has a legal secretary present to take notes, as well as an interpreter to interpret the client's foreign language, confidentiality is not destroyed. The idea here is that all of those third parties are present so that the parties can effectively communicate. There's someone there taking notes, there's an interpreter there helping communication between the lawyer and the client. There's an accountant present to answer questions or to assist the client and helping the lawyer. Therefore, we have privilege even though there are third parties present for that communication. Turning to the second example, if a client has a discussion in a coffee shop where other customers can easily hear the conversation, then there's no privilege. Again, context matters. Next, let's talk about what's not protected by the attorney-client privilege. First, generally the identity of our clients and our fee arrangements aren't covered, absent exceptional circumstances. So just to stop there, identities of our clients, the reason we can divulge that type of information is because we have to. Think about conflicts of interest and trying to detect if a conflict of interest exists. We often have to divulge client names to determine if we have a potential conflict. This information really isn't giving up anything that's private. Further, remember there are rules that regulate lawyers and their fee agreements that they reach with their clients. So it would be really silly for us to have all these rules that regulate our fee agreements that we make, but then simultaneously call those fee agreements privileged, because then we can never truly be regulated as to those agreements. The second exception about what's not covered with the attorney-client privilege is pre-existing documents and evidence. Please be careful with this one. We have seen some questions that test this and they can be tricky. Remember, the attorney-client privilege protects those communications between the attorney and the client. Turning to the example in your outline on this point. A client comes into the attorney's office and says, "I just stabbed my boyfriend with this knife and I killed him." So stopping there, the communication, literally the speaking between the attorney and the client is going to be privileged. But as it relates to the knife, which is clearly evidence relating to this event, the lawyer shall not take the knife. If he does, then he needs to hand it over to the authorities. So that's why we say he shouldn't take the knife. Now, the attorney can tell the client to go put the knife back where he found it. The attorney cannot tell the client to go hide it or to destroy it or anything like that. Therefore, to recap, the knife is not protected, but the communication, that admission of guilt between the parties, that is protected. As it relates to the attorney-client privilege, your client holds the privilege. It's theirs to waive or theirs to assert. Now, the lawyer has a duty to invoke the privilege if the client is not there to claim it. The privilege lasts forever. It survives the termination of the attorney-client relationship, and it even survives death. So, if an attorney and a client part ways, the attorney still has to keep that confidential information protected. Additionally, even once the client's dead, the lawyer still has to keep that information protected. Now, there are 4 exceptions to privilege, and as you can imagine, MPRE questions will likely test the exceptions rather than just the general rule. So be sure you're reviewing these. The rule states that the attorney-client privilege does not apply if the client seeks the attorney's services to engage in or assist a future crime or fraud. So if a client sits down in the lawyer's office and tells the lawyer that he needs help lying on a business loan application, that communication is not privileged. Why? Because while it might be a confidential communication between the lawyer and the client, it's only being made because the client wants to break the law and wants the lawyer's help in doing so. So this is not protected. The second exception. The privilege does not apply to a communication that's relevant to an issue of breach by either the attorney or by the client of the duties that arise out of their relationship. Turning to the example in the outline, a client is months behind paying the lawyer for her past services relating to the divorce. Lawyer can file a lawsuit against that client to try to recover these past due fees. Lawyers are also able to divulge statements made by the client relating to his lack of payment. Lawyer can't, however, reveal information relating to the client's divorce that's unrelated to payment. Thus, this exception is narrow. The lawyer can only reveal as much information as is necessary relevant to the issue of breach. The third exception. The privilege does not apply in civil litigation between 2 persons who were formerly joint clients of the attorney. This is probably the trickiest one for most people. This is why most clients do not agree to joint representation with a lawyer, because it can be unfortunate for them and the outcome, depending on what happens with their case. Let's look at the example. It says a lawyer represents clients A and B in a business transaction. Later, A sues B regarding that business deal. Neither A or B can claim privilege to prevent either party from repeating things said between the lawyer, A, and B in that previous transaction. This is why before lawyers take on joint representation of clients, they really should warn them about this and this issue in the exception to privilege. The theory behind this rule is that the rule is treating those joint clients as one. So these 2 clients are one person for the purposes of this rule. And as a result, you can't assert privilege against yourself. Thus, A can't assert privilege against B because it would be tantamount to A asserting privilege against A. Likewise, B can't assert privilege against A because it would be like B asserting privilege against B, which we know does not make any sense. Therefore, this is the risk that they're taking by agreeing to joint representation, that they can both divulge information that was communicated between themselves and the attorney, even confidentially, regarding this transaction. The fourth exception. It says privilege does not apply when the attorney can furnish evidence about the competency or intention of a client who gives or attempts to give property by will or during life. For example, a client has a lawyer draft a will, leaving all of her property to one of her 2 kids. And the client brings a list of reasons why she's disinheriting one of her children. Upon client's death, the disinherited child contests the will. The lawyer can furnish evidence of the client's capacity and her wish to disinherit that child. So while technically it is divulging some confidential communications, this exception speaks to a situation where the lawyer can do so ethically. So now that we've covered privilege, you know the general rule and you know its exceptions, let's turn to the duty of confidentiality. So first, let's start with the general rule. And then I want to compare it just briefly again to the attorney-client privilege. So turning to the rule first. It states that a lawyer shall not reveal information relating to the representation of a client unless the client gives their informed consent or the disclosure is impliedly authorized in order to carry out the representation, or disclosure is permitted. The confidentiality rule applies to both matters communicated in confidence by the client to the lawyer and all information relating to that representation, whatever its source may be. So comparing this rule to the attorney-client privilege, You can see that the duty of confidentiality is much broader because it's not just going to protect those things that are directly said between the lawyer and the client, but everything else that the lawyer learns about the representation throughout the representation, no matter who he or she learns it from. A quick example on this point. Let's say that I'm a personal injury attorney and you hire me to represent you related to an accident that you recently sustained. One day you sit down with me in my office, we shut the door, and we're having a private conversation about all of your injuries by virtue of this accident. All of the information you give me would fall under the attorney-client privilege. Why? Because it's a communication between the lawyer and the client, and we're treating it as confidential, and therefore it's privileged. However, you leave my office and you give me permission to gather all of your medical records because, of course, I need to study your medical records in an effort to build my case. My paralegal helps me study those records and she helps me summarize them. Everything that I'm learning in those medical records is not privileged. Why? Because you're not reading them to me. Therefore, it's not a communication between the lawyer and the client. But it's information that I'm learning throughout the representation about the representation. And therefore, it's confidential and it's protected under the duty of confidentiality. Additionally, the injuries that you told me about when we met in my office, those would also be confidential because it's information relating to the representation. So, hopefully now you can see how privilege is narrow, as it would only cover the communication between you and I, my client, where confidentiality would cover all of that information, including that communication and so much more. It would cover everything I learn about you in the review of your medical records. Now that you know the general rule, note that the duty of confidentiality lasts forever. It continues after the lawyer-client relationship is terminated and even survives death, just like privilege. Next, let's talk about disclosures that are expressly or impliedly authorized by the client. The rule specifically says we shall not be revealing information relating to the representation unless you have informed consent from your client. That's the first instance, express disclosure. And you can imagine you won't get a lot of questions that test this on the MPRE because it would be a little bit too straightforward. But if your client expressly authorizes you as their attorney to reveal information, then you can reveal it. The rule goes on to say that if you don't have that informed consent from your client, you can disclose information if disclosure is impliedly authorized in order to carry out the representation. Let's dive deeper into what that means. The rule tells us there are specifically two situations in which implied authorization exists. The first situation in which it exists is when a lawyer is impliedly authorized to make disclosures about a client when appropriate in carrying out the representation, unless the client's instructions or special circumstances limit that authority. Thus, the lawyer is allowed to reveal information that is necessary for them to do their job, to carry out the representation of the client. The example in your outline on this point is very helpful. It says that in some situations, lawyers can be impliedly authorized to admit a fact that cannot be properly disputed, or to make a disclosure that will facilitate a satisfactory conclusion to a matter. So if a lawyer is representing a woman in a divorce case, the lawyer could admit that the woman makes $500 a month selling candles on Etsy, even if this would ultimately reduce her alimony award. This is an honest disclosure that would be necessary to resolve an alimony dispute. The way I like to think of this is it's something that couldn't be denied. The court can get their hands on this woman's tax records. They're going to see that she has an income, and therefore it's the type of thing the court is going to expect the lawyer tells them when making a decision regarding alimony. Thus, the lawyer would be impliedly authorized to make this disclosure. Another example, not in your outline. Let's say you're a personal injury attorney and someone hires you to defend them in a car accident case because they got sued for hitting someone. Let's say the complaint against your client says they were driving down Main Street at 5 p.m. on the day in question. It would be very hard to deny that fact if your client admits to being part of the car accident. Now, your client might deny fault. That's a totally different story. But if your client admits to being part of the accident, You would likely have to admit the fact that he or she was present at the time and place when the alleged accident took place. So, again, that would be confidential information that you would be impliedly authorized to disclose because you would have to be able to carry out the representation of your client. Now, the second instance of implied authorization is that lawyers in a law firm, in the course of their practice, can disclose to each other information relating to the client of a firm, unless the client has instructed that particular information be confined to specific lawyers. The way I like to think of this rule is in the context of a big law firm. Clients love to hire big law firms because they know that ultimately many lawyers with experience will be working together to handle their legal matter. So, to stop there and to recap, the way I like to think of the duty of confidentiality is having three parts. You shall not reveal confidential information relating to the representation of a client unless you have one of these three things. First is that you have informed consent from your client, which you likely won't have for purposes of the MPRE. Two is that one of these implied authorization scenarios apply. Remember, there are two instances in which implied authorization exists, and we just covered them. Now, the third instance in which you can reveal confidential information is if one of the exceptions to confidentiality apply. There are 7 exceptions. I know that's a lot, but you should do your best to memorize them. Because as you can imagine, just like I said with the attorney-client privilege, most of our questions will test these exceptions. The first thing about the exceptions that I want to point out is that the rule uses the word may. It says a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary. So if one of these situations apply, you never have to reveal information, but you can if you want. The first exception says that a lawyer may reveal information relating to the representation of a client to the extent that the lawyer reasonably believes necessary to prevent reasonably certain death or substantial bodily harm. Thus, if you have information and you want to disclose it because it could prevent that reasonably certain death or great bodily harm, then you could do so without getting into any ethical trouble. The example in the outline says a lawyer who knows that a client has accidentally discharged toxic waste into a town's water supply may reveal this information to the authorities if there is a present and substantial risk that a person who drinks the water will contract a life-threatening or debilitating disease. And the lawyer's disclosure is necessary to eliminate that threat or reduce the number of victims. The second exception is our crime fraud exception. But this is much more narrow than many people think. It says a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary to prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interests or property of another, in furtherance of which the client has used or is using the lawyer's services. So to be clear here, if your fact pattern tells you that a client tells a lawyer that they committed a crime or a fraud in the past tense, and they're just hiring the lawyer to represent them in that criminal matter, then this exception doesn't apply. This only applies if the lawyer has been used or is being used to commit a crime or fraud. So make sure you're reading these scenarios very carefully. For example, while representing Patty plaintiff in a civil suit, Attorney Andrew discovered information that led him to reasonably believe that the defendant in the case committed a crime. Since Andrew learned this information during the course of his representation of Patty, it's confidential, and Andrew must seek Patty's permission if he wants to disclose the information about defendant's crime to the local authorities. This disclosure would be permissive and not mandatory. The third exception says to prevent, mitigate, or rectify substantial injury to the financial interests or property of another that's reasonably certain to result or has resulted from the client's commission of a crime or fraud, in furtherance of which the client has used the lawyer's services. As it relates to this exception, the lawyer can reveal whatever information is necessary to accomplish this. The fourth exception is all about ethics, to secure legal advice about the lawyer's compliance with these rules. However, the attorney should not reveal enough to disclose the identity or exact circumstances of the client or scenario that they're asking about. Many states have ethics hotlines that a lawyer can call and give a hypothetical situation and ask for advice about their compliance with these rules. You're allowed to do that as a lawyer because we want lawyers to comply with these rules and to provide them assistance if needed. But they have to be sure that they're not giving up the client's name or identity or enough information to identify that client. The fifth exception is to establish a claim or a defense on behalf of the lawyer in a controversy between the lawyer and the client. To establish a defense to a criminal charge or a civil claim against the lawyer based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of a client. We like to call this preemptive self-defense. Please keep in mind that the lawyer is allowed to exercise their rights under this exception, even if they have not been sued or even if they have not yet been charged. Thus, if the lawyer knows that trouble is coming and they need to reveal information to clear the air about their participation in something or to protect themselves, they can. They do not have to wait until they've been sued or they're cuffed in the back of a cop car, for instance. Turning to the example, it says, attorney defended a defendant in a larceny case. Defendant admitted to stealing the property at issue. Attorney refused to call an alibi witness whom the attorney knew would testify falsely. If the defendant sues the attorney for malpractice, the attorney can reveal the confidential statements made by the defendant to show why the attorney did not call that alibi witness, and therefore has a defense to the malpractice claim. Therefore, we can see how this ability to reveal information is there to protect the lawyer. But again, it's limited. The lawyer needs to be careful that they're only revealing as much information as is necessary. The sixth exception to confidentiality is to comply with law or court order. Absent getting informed consent from your client, the lawyer should always assert on behalf of the client any and all non-frivolous claims that the order in question is not authorized by law or that the information is being sought by the court is protected against the attorney-client privilege or any other applicable law. In the event of some sort of adverse ruling, the lawyer must consult with the client about the possibility of an appeal. And unless review is sought, this exception permits the lawyer to comply with that court order or law, requiring revealing that confidential information. So, turn to your example on this point. A court orders that a lawyer is required to divulge a client confidence. So the lawyer should assert every single non-frivolous argument in an attempt to avoid being forced to divulge this client confidence. If he loses, he should consult his client about the possibility of an appeal. If the client doesn't want to appeal, then the lawyer should comply with the court order and divulge that information. The seventh and final exception is all about conflicts of interest, to detect and to resolve them arising from lawyers' change of employment or from changes in the composition or ownership of a firm, but only if the revealed information would not compromise the attorney-client privilege or otherwise prejudice the client. In this instance, lawyers switching firms or two firms merging together, the affected lawyers have to do their due diligence to make sure that there isn't going to be a conflict of interest. In doing so, they can reveal some information to try to detect these conflicts of interest. The rule tells us that these disclosures should ordinarily include no more than the identity of the persons and entities involved in the matter, like client name, for instance, a brief summary of the general issues that are involved, and information about whether or not it has terminated. That wraps up this section of the rules.